much more interesting things. Thank you for your attention. But we have, next on the agenda, we have Bridget Wilson, who is local San Diego attorney and is an expert in Don't Ask, Don't Tell, and is going to bring us up to date about the concretia of the policy and also its implementation. And she's authored a book on the subject and has done lots of litigation related to this issue. So let's all join together and welcome Bridget Wilson.
Julie and I are the short people out of this group. I may need to adjust this a little. Good evening. My name is Bridget Wilson, and as was mentioned, I'm an attorney, and it's always interesting for us to be in a room full of psychologists because we're lawyers, we don't have feelings. But in reality, we are, in fact, this is going to be hard for me because I tend to walk when I'm talking in front of a group. But really, lawyers on some levels are the world's best amateur psychologists. In fact, we keep a DSM current on the shelf of our office all the time. And I want to, for all of you who know what this might mean to a lawyer, we see a lot of access to disorders in law offices. And so I'm sure that you can appreciate that. And to some extent, we also deal with people in crisis all the time. So when we're talking about what we do and what I do in this realm, please understand that it has its own human context, and I'm the context maker, hopefully not being too dry in discussing that context. Let me ask a question I always ask at the beginning of these things. Would anyone in the room who's a veteran raise their hand? Okay. It's a fairly large number in a group like this, and what I've noticed is a lot of them tend to be not the youngest people in the room either. That's in part because once upon a time we had this thing called conscription, a draft. And so for a very long time in our society, our people knew what the military was, because everyone had a father, a grandfather, a brother, an uncle, a cousin who had served in the US Armed Forces, whether they wanted to or not, for at least 2 years, right? Now we have probably the second generation of people in place for whom military service is rather an unusual occupation once you get out of a place like San Diego County. There was just headlines in the paper, I think today, about how the military is spending more operational money in San Diego than anywhere else in the continental United States. So we sort of get inundated with it, and we sort of think that everybody knows what this world is. And in fact, most Americans have no idea what people in the military really do. They either see them as villains or put them on impossible pedestals. And at the end of the day, they're all still human beings, okay? I'm one of those, Jules is one of those, Rob is one of those, Jason is one of those, and some of those people happen to be gay. The military has had long-standing, US military in particular, prohibitions on service of people they call homosexual. And it's been going on for a long time. I served in the military before the actual policy of Don't Ask, Don't Tell, gray hair folks. But one of the things that we did, my friend Shara Greer, when she was working at the advocacy group Service Members Legal Defense Network, for whom I've been consulting counsel since this policy was not yet quite born, discovered that they really had changed about 6 words from the prior policy. So my job is to kind of give you an idea of what Don't Ask, Don't Tell really is and is not. So I'll start with giving you a little bare bones outline and then tell you what really has and has not changed with the highly touted revisions that were set forth on the 8th of April. Okay, number 1, what has not changed? Homosexual conduct is the basis for being thrown out of the military. One of the words they changed was they removed the word homosexuality. Prior to Don't Ask, Don't Tell, you could be thrown out for being homosexual. Now you can only be thrown out for engaging in homosexual conduct. Now, Actually, I think a lot of people think that makes it sound like you're having, sex in formation or something. In reality, it's a whole lot easier than that to fall prey to violating the rules against homosexual conduct. There are 3 bases upon which you can be thrown out of the U.S. Armed Forces for engaging in homosexual conduct. Homosexual conduct includes engaging in, attempting to engage in, soliciting another to engage in homosexual acts. 2, a statement that the service member is homosexual or bisexual, or words to that effect. 3, a marriage or attempted marriage to a person known to be of the same biological sex. Now, up until very recently, marriage cases were actually pretty rare. You rarely would see them because no one was getting married, okay? I would occasionally see a Marine who had married his preoperative transsexual sweetheart, and that would be the marriage case that I would deal with in San Diego County. Now, actually, there is a marriage thing to be looked at. And a friend of mine who serves in another state's National Guard had gotten married in Massachusetts, and a vindictive guy in her command looked it up and found the marriage license and turned her in. So please understand how broad this policy is. You cannot tell anyone. You can do everything you can to try to conceal the fact that you are gay and still get thrown out under Don't Ask, Don't Tell. And you need to know that. Now, hypothetically, you can stay in. There's supposed to be a loophole in Don't Ask, Don't Tell that we who work in it have affectionately called the Queen for a Day or Gay for a Day provision. And the Queen for a Day provision says basically that the conduct was a departure from this individual's, the act engaged in was a departure from this individual's normal behavior. And that under the circumstances, their retention would be good for the service, and that actually they are not a person who has the intent or propensity to engage in homosexual acts. And one of the things Don't Ask, Don't Tell prohibits is having people in the ranks who demonstrate a propensity to engage in homosexual acts. Now, you may be asking yourselves how one can have a sexual orientation that does not include propensity. And if any of you can come up with the answer to that question, call me. Because you can't. But that's what it says. So you can stay in after they have discovered that you've engaged in homosexual acts, as long as you show them that you only did it once, you didn't really like it, and you'll never do it again. Okay? Therefore, the Queen for a Day provision, as we choose to call it. Now, you may say, well, okay, so you have to be celibate in the military. I suppose you could do that, but for those of you who have been in the military, celibacy is not an occupation in the U.S. Armed Forces, I think you can safely say. But we want to talk about what a homosexual act really is. Because you're going, well, you can't have sex, right? Jules. We just had sex under Don't Ask, Don't Tell. Okay? A homosexual act is any physical contact, actively or passively undertaken for purposes of sexual gratification, or that a reasonable person would believe was for purposes of sexual gratification. Are you with me? So it may include a lot of things, does include a lot of things that have nothing to do with sex. See, because here's what happens. If we're in a place like this and someone knows that I'm a lesbian, and they suspect that Julie's a lesbian, and they see me with my arm around Julie, a reasonable person would suspect that that might be for purposes of sexual gratification. I'm a little old for her, so I'm not even going to go there with that. Women old enough, young enough to be my daughters are just not happening. Not to mention that I've been attached for 3 years. But I think what you want to understand is that how broad this policy is. Number 2, a statement. It's not only just saying I'm gay or I'm homosexual, but words, language, or behavior that a reasonable person would believe intends to convey a statement that one is lesbian, gay, or bisexual. And by the way, Don't Ask, Don't Tell is one of the few laws I've ever seen in the world that expressly prohibits bisexuality. It's an interesting little trivia piece. because that statement would convey that this person engages in, attempts to engage in, or intends to engage or has a propensity to engage in homosexual acts. Okay, that's really the nutshell of Don't Ask, Don't Tell, even after all the changes that you've seen. You can still be thrown out for saying you're gay, certainly for being found to have had sex in the privacy of your home, off duty, off base, completely unknown to anyone, as far as you know. There is no privacy. If you tell someone you're gay, if you tell your mother you're gay, and she decides she doesn't think you should go to Iraq, she could get you thrown out by sitting down with your commander and saying, my son is gay. Please understand that. Please understand how broad the scope of this is, because what you're looking at is the kind of hiding that people must do, that over 35 years of helping people with the military's anti-homosexual policies is really soul-rending, okay? It changes how people see themselves. So, that is still there. You've heard about some new regulations. How am I doing on time? I'm just going to finish. Okay. You know, because I've now done an hour lecture in about 10 minutes on Don't Ask, Don't Tell. I usually do about an hour on this because it is a sufficiently complex stack of regulations based on a statute. And I'm trying to communicate to you something relatively pages and pages of document in a short discussion. But some of the changes that have happened. Well, there have been limits put on some of the reports that will be taken from third parties, okay? And for example, a person who has a grudge against you may not be considered as a credible witness under the new enforcement of Don't Ask, Don't Tell. May not be. Didn't say they wouldn't be, but might not be, okay? Someone who has a grudge against you, a stalker, someone who's committed domestic violence. In the past, I've had clients who filed domestic violence restraining orders who were discharged from the Navy based upon those documents. The batterer goes to the command and said, see, we have a dating relationship, and discharged my client. I don't make this stuff up, okay? That's probably done with. There's a big change in the level of the person who can initiate discharge proceedings and investigations, okay? Inquiries, as they call them, because they're not really technically investigations, they're inquiries. That gets reached up to really the person in charge of it is going to be someone who's an admiral or a general, a star officer of some kind, all right? Now, that sounds like a really good thing, and actually I think it will keep people in some of the more questionable cases where stalkers and ex-husbands and wives and people with grudges and anonymous phone calls are no longer credible evidence for separating you. That'll save some people, it really will. And the other thing that will save some people is no one wants to put another piece of paper on a general or admiral's desk, okay? And I do think that that will keep the processing at a lower rate. But those really, the third-party reports that we're talking about under the new Don't Ask, Don't Tell, are really a relatively small number of the people we see separated for Don't Ask, Don't Tell. I would tend to bet in the last 10 years, most of what I've seen, and truly in the last 5 years, are related in some manner to social media. Texting, Twittering, and the internet. Hot Marie looking for same near Fallujah will get you into trouble. Just trust me, okay? Just take my word for it, okay? Yes, they're laughing because they know it's, they know it. You know, and there have been some limitations put on certain types of other things that won't be used for credible information to initiate homosexual conduct discharges. For example, information given to lawyers, clergy, and psychotherapists. Well, some of that's kind of a red herring. I hate to tell you this, ladies and gentlemen, but the information you give to your lawyer is always privileged, okay? Unless you're committing an ongoing crime and you're expecting your client to cooperate with it, even if you are in some states, your information that you give to your lawyer is always a privilege. So this is not a big deal. They're not giving us anything here. Psychotherapists. Every psychotherapist I know in the Navy, at least right now, is scared to death of HIPAA and all the other privacy laws and won't give you diddly without 16 authorizations and meeting with the patient. Okay, so that's absent Tarasoff stuff, nah, not so much a big deal. And clergy, which we have had problems with clergy who have felt compelled to turn people in. Yes, indeed. Isn't that heartwarming? I've seen people turned in by clergy, by chaplains. I have never seen a chaplain punished for violating the confidence of a service member regarding homosexuality. And if that doesn't make you angry, it should. The problem is that it applies in the same way that the court-martial or courtroom privilege does, and what that means is that it has to be within the course of pastoral care, which might lead a whole lot of gay people to think that chaplain's more safe than they are. Okay? So to some extent, that will actually keep some clergy members from doing anything with it. It'll keep any of the psychotherapists who would have given out information from doing so. And all the lawyers who are so unethical they really want to lose their bar license, it'll keep them honest as well. And even if they do, any information from those people would not be credible information to separate you. Information you provided to a medical professional in the furtherance of medical treatment. Now, that makes gay people in the military have the most protected medical records of anyone in the U.S. Armed Forces, because there is no medical privilege if you are in the U.S. Armed Forces. At least now there is for gay people. It's a fascinating change. I wonder if anybody at the Pentagon was, I don't know who drafted these. Information conducted in the course of security clearance investigations. Actually, even though it wasn't a rule, my experience in the last decade has been that security clearance interviews, no one was going to turn you in from them. And there are some other changes, okay? But these are examples of those changes. It's like, like this, okay? I'm not going to go into all of these changes. But let me tell you a couple of things that did not get changed. One of the things that makes me completely crazy, a couple of years ago I had a client who was a victim of a sexual assault, a man who was the victim of a sexual assault from another man. And it turned out that the assailant had been cruising the internet looking for guys. And one of the things he was doing was not telling the guys he was meeting up with that he had HIV. So that's the first problem my client had. The second problem my client had with the military officer was that he was granted immunity from criminal charges and forced to testify under oath in the court-martial against this guy. That sworn testimony became the basis of him losing his career. So you can still be compelled to make statements that will lead to your separation under Don't Ask, Don't Tell by being the victim of a crime, by reporting a crime. There's some exceptions with DV, there's some other things. We don't know if hate crimes are included in that. These are issues that I've dealt with a lot, okay? There's a lot of things that still aren't fixed. There's some things that are so obviously in need of being fixed, like the victim of crime part of this, that I was stunned to see that those changes were not included. And there are some other parts of the processing with regard to evidence and that type of thing that actually make things worse for people who end up in front of a board, okay? And I don't have the time to go into some of these things, but understand that this is not as good a deal as you've been led to believe. So the only good thing to do with this policy is to get rid of it, is to repeal it, and put in its place some administrative provisions that set forth a uniform misconduct policy. The opposition to this will say things like, well, those people will engage in misconduct. Great, you do for anyone who engages in misconduct, you prosecute them or you get rid of them, okay? We're not arguing that gay people have a right to engage in misconduct in the U.S. Armed Forces. What we're asking for is a uniform code of misconduct, that the laws be enforced equally, and that people not be being separated for it because they say they're gay. Years ago, and then I'll get off the Mike here. In the 80s, there was a witch hunt in a naval training station, Great Lakes, which was the Corps school, one of the Corps schools. It still is the Corpsman School now. And one of the fellows was brought in, and he said, he made some comment. When he was asked to name names of other service members, he said, well, they're just all friends of Dorothy. Now, unless you're a really older homosexual, you may not get that reference to the Wizard of Oz. But in the old days, in the old subculture of being gay, people used to refer to each other as friends of Dorothy if you were in a public place. Naval Criminal Investigative Services went to the gay bars and started asking people in them for friends of Dorothy. I didn't make that up. So what I will do, I am going to leave you. I have given you the briefest thumbnail sketch of Don't Ask, Don't Tell. I do want to talk indeed about the effects that I see on service members, what it has done to their lives, and what it is like to lose the thing you love the most. Big deal.